Thank you very much for joining the session. This is second time when we have honor to host you. Last time it was during the World Human Rights Day some years ago. Thank you very much for your decision that you agree to be a part of this meeting. Thank you very much. So
thank you very much for the invitation.
It's a pleasure for us and a great honor. So I can see that we have almost all speakers, with one exception, but I know that because Alex Pérez from Lisbon, he will join us a little bit later because he has some other meeting, but I hope that it will be possible, and I hope that without any technical problems the session will be excellent and we will have very interesting and fruitful discussion. So Oscar, so I think that we can start, yeah?
Yeah.
Oh, for maybe 4 seconds. 3, 2, 1, 0. Okay, 6 p.m. in Poland. So it's a great honor and pleasure to host all speakers and all members of Research Committee 26 on Human Rights, the International Political Science Association. So today, like every year, on 20 June, the world celebrates the strength and courage of people who have been forced to flee their home country to escape conflict or persecution. World Refugee Day is an international day designed by the United Nations to honor refugees around the globe. The day was first established on 20 June 2001 in recognition of the 50th anniversary of the 1951 Convention relating to the status of refugee. According to the United Nations, today we have almost 120 million refugees in the world. But what is also important, the number of refugees has increased by 10% since 2022. So this year's theme announced by United Nations this day is solidarity with refugees. We would like to be solidarity with refugees, and we would like to celebrate also this day. So it is great honor for me as a chair of Research Committee 26 to host excellent speakers and very prestigious persons. But this is not the first webinar. Since 3 years, as I mentioned, we have celebrated Human Rights Day. This year we first time celebrated the World Press Freedom Day in May, and this webinar, this is an example how we would like to celebrate this day announced by United Nations. So we have special guests, special speakers. So let me introduce very shortly Professor Felipe González Morales from University Diego Portales in Chile, but also former United Nations Special Rapporteur on the human rights of migrants in the years 2017-2023. Professor Denise Gilman from University Texas. I will present more broadly before the speech every person. So it is a pleasure for me to host also my colleague from my university, Professor Anna Potyrała from Adam Mickiewicz University in Poznan, Poland. So I hope that Professor Alexander Xavier Pires from Lisbon University will also join to this session. So this is a big pleasure for me also that together with us is also Professor Cláudio, Carneiro, Bezerra, Pinto, Coelho. I'm sorry for pronunciation, but I hope that it was quite good. Lawyer, professor, and writer from Brazil. And also, last but not least, my colleague from National Chamber of Legal Advisors in Poland, Magdalena Bartosiewicz, attorney at law in Warsaw, and she was also the director of a special center on the eastern border of Poland. So I hope that Magdalena Bartosiewicz will present also her experiences on this field. So once again, thank you all speakers to join this session. This session we will chair together with Professor Oscar Pérez de la Fuente, from my colleague, from my friend, and Vice Chair of RC26 from Carlos III University in Madrid. We have short roles, so I will coordinate the meeting, and Oscar will ask questions to our guests. The plan for the meeting is that first, we will invite three speakers according to and next. So we will have some question from Oscar and maybe from other persons. So we can say that it will be a short debate. And after that, we will have the next three speakers and the same questions and debate, and some summary on the end. Okay, so let's start from first speaker, Professor Felipe González Morales, as I mentioned, from Universidad Diego Portales in Chile. But so Professor was also United Nations Special Rapporteur on the human rights of migrants in the years 2017-2023. But Professor was also the President, Inter-American Commission on Human Rights, Director, Master in International Human Rights Law at University Diego Portales in Chile, and of course, Professor has also other positions and duties, but so I think in a very short way, I tried to present the position of our special guest. So Professor will present the topic about current issues on the human rights of refugees. Yeah. So, professors, the floor is yours. Okay.
Good afternoon. Thank you very much for the invitation to this webinar, and glad to be again with the research committee on human rights at the International Political Science Association. I remember the last time was at that time I think it was in December 2021, when I was about to go to Poland, but in the end, due to the Omicron, that visit was postponed until the summer of 2022, when I visited the border of Poland and Belarus and addressed the situation in Poland to a wider extent, because the war in Ukraine had already begun. So I'm very glad to have this interaction with you today. I would like to start by making an observation, which is that the mandate that I held as the chair of the committee pointed out was about migrants. And the issue of refugees, at least explicitly, is not part of the special procedures of the United Nations. And of course, there is a huge, big agency on refugees, which is UNHCR, as all of you know, of course, but there is not an agency as such. And I think that this has to be with the fact that on the issue of migration, in the narrow sense of the expression, there is a consolidated framework of norms, as in the case of refugees. So the need for a special rapporteur or a mandate was much more acute. However, this doesn't mean that the issue of refugees was addressed by the mandate, or is addressed, particularly on the issue of the asylum seekers. Because as you can see around the world, in all continents really, there are many would-to-be refugees who stay in the situation of asylum seekers, sometimes indefinitely, either because they are not able to lodge a request for asylum status, or because if they are allowed to do so, the procedural grounds or the substantive standards at the domestic level are so high that it becomes virtually impossible for them to achieve that status. So, in my experience as Special Rapporteur at the UN on the human rights of migrants, the issue of asylum seekers was permanently present. And in all the country visits that I did, and in the thematic reports that we presented to the General Assembly and the Human Rights Council of the United Nations, the issue of asylum seekers was present. So I think that is a relevant point to be made from the very beginning. In this respect, I think that there are many challenges and trends that are important to mention. I would say that the very right to seek asylum is under siege these days in many countries. Countries in many, I mean, in all continents, not all countries, but many countries have amended their domestic legislations so as to make it much more difficult to lodge requests for asylum, not to speak to get the asylum as such. So this has been done through several means. For instance, this has been increasingly done through policies of externalization, but countries do not allow the asylum seekers to enter into a territory to seek asylum, but they have to remain in another country or are sent back to another country, and they have to lodge their requests from there. And this has been repeatedly described as a violation of international refugee law by international organizations of human rights. We can see this trend in the United States and in our countries. Sometimes in explicit manners through agreements with our countries who will receive these persons, such as in the case of Denmark or the US or the UK with Rwanda and other cases, or sometimes in a more subtle way by establishing Rwanda of understanding with other countries so as to have those countries impeding, banning persons from moving forward in order to reach the territory of the state at which they want to lodge a request. I'm thinking, for instance, about the agreements between European countries and some countries in Africa, like Niger or Mauritania, so as to have those states putting obstacles to human mobility to the north. There is the issue of pushbacks, which is a very worrisome trend also around the world. By pushbacks, we understand them as expulsions or actions that impede a person to reach the territory of a country. Many of those persons allegedly are going to request asylum, so the very right to seek asylum is affected. This is a practice that developed strongly in countries of Europe, in the United States, and other countries, but nowadays it's really around the world. We can see this in many countries of Latin America, for instance, and countries of our regions as well. So that's another point that is a very worrisome one. There is the issue of the non-refoulement principle and how this is being violated on a massive scale by many countries. According to the non-refoulement principle, a person cannot be sent to a country, either his or her own country or a third country at which the person is going to be in peril. There is the situation of refugees as such, but for asylum seekers, the Convention Against Torture and international customary law applies, and so they cannot be sent to countries in that situation. But increasingly, this is becoming a more repeated trend by which persons are indeed being sent to third countries which are not safe. There is the issue of administrative detention for asylum seekers. I would say that in many countries, this is practiced at not as a result of establishing a criminal such to the irregular entry into a territory. But in practice, this has very concerning features as well, because often there is no term limit for the person to be detained. There are a lot of restrictions for these persons to get access to justice, an issue that I'm going to address later. And in general, it is practiced on a massive scale by a number of states. So the issue of eliminated from the criminal code the crime or irregular entry into a territory is not a solution by such, as long as administrative detention based on the migratory status of the person continues to exist. In connection to this is the issue of access to justice. And I think this is a key point because it affects the situation of asylum seekers in many respects. In this regard, for a person who has lodged a request for asylum, it becomes much more likely that he or she will get it if he or she has a legal representation. And in many countries, this is not the exception. So there's really a problem in this regard. There is also the issue of the type of authority to which the person can reach. Is this going to be exclusively at the administrative level? Is the person going to be able to reach exclusively an administrative functionary, or he or she can reach a judge as such. There is an intermediate way also, which probably Professor Denise Gilman can explain better, as in the US, where there is these migratory judges who are not part of the judicial system as such. But in any event, in most countries, the possibility of reaching a judge is very limited, and this has a significant impact on the ability of a person to actually achieve refugee status. There is also the issue of due process of law in connection to this. And there is a paradox here because, as I mentioned before, nowadays most countries are not criminally prosecuting asylum seekers for having entered into a territory irregularly. In fact, they proceed with these administrative cases, and the due process standards are much lower than in the case of criminal prosecutions. Of course, I'm not advocating the restoration of criminal prosecution, but I'm calling the attention about the problems with due process of law in cases at which almost all the procedure is taken in administrative arena. And the fact is that the issue of access to justice is not only connected to the procedure to obtain refugee status, but also, for instance, in connection to other public services. Sometimes the possibility of litigating to get some access to public services might be severely impaired without legal representation, for instance. There are a number of other issues that apply both to asylum seekers and to refugees as such. For instance, I would stress the issue of the investigation of the abuses committed against them. In many country visits that I conducted as special rapporteur, I found out that there was a very poor record of prosecution of abuses of asylum seekers, refugees, or migrants in general. So, for instance, I call on the countries of origin to take a more proactive action also to have consulate services which are active. But in the cases of refugees, of course, this is not the refugees as such are not applicable because are escaping from the situation of their own country. So the responsibility lies with respect to the investigation. There is the issue of discrimination and racism against refugees and asylum seekers. In this regard, the fact that the refugees have a recognized status in a certain country does not automatically bring them to normality. And we can see in many countries how discrimination and racism is pervasive against refugees, and not only against migrants in general. There is the issue of civic participation, freedom of association, the issue of labor rights. It depends on the countries, the issue of to what extent, for instance, refugees can play roles in this regard. There is the situation of the human rights defenders, and there is a paradox here also as well, because we have seen over the last decade or so that the civil society has expanded its work in many countries on the issue of human mobility, broadly speaking. This despite the abuses committed against them and the obstacles presented to their work by a number of states. the fact is that the civil society has become much more involved on the issue of human mobility. And this includes both NGOs specialized on the issue of human mobility, and the fact that the human rights NGO with a larger mandate also virtually always have an engagement with the issue of human mobility as well. This is a challenge as well, to be sure that to make sure that they can do their work with freedom and in an effective manner for the protection of the rights of refugees or asylum seekers. In a more general, there are many other aspects of course, that could be mentioned, but I would like to stop here on the list of issues and make a more general set of observations. In this regard, I think that it is important to consider that we are in front of two sets of norms here. One is the international refugee law, and the other is the international human rights law with regard to migrants. The international refugee law is a consolidated framework of norms, starting with the Convention on Refugees from more than 70 years now, and the UNHCR as the largest agency at the global level. On the issue of migration as such, there is no such corp of norms. And for instance, in the work of the Special Rapporteurship on the Human Rights of Migrants, we had to rely on many different sets of norms, really, because the ratification of the Convention on the Rights of Migrant Workers is very limited, about 1/4 of the UN states only. So we had to rely on those treaties that have been ratified by the state that would be applicable. For instance, the International Convention on Civil and Political Rights, the one on Economic and Social Rights, the Convention against Discrimination Against Women, the Convention on Racial Discrimination, the Convention on the Rights of the Child, the Convention Against Torture. But that requires a much more complex process than simply applying the international refugee law, as in the case of persons who already enjoyed the status of refugee. And the problem is that for asylum seekers, in many situations, we had simply have to apply the more general international human rights law. And this is disputed by states. So I think it's a matter, it becomes a matter of interpretation on many cases, and it dilutes in a way the strength of the international human rights bodies to approach the situation. It also makes more difficult for judges at the domestic level to apply international law when they have to rely on many treaties and treaties that have been ratified by the respective state, not the ones that have not been ratified. So the situation of asylum seekers becomes very difficult. I think there is an important challenge in this regard. I think it's very important to make sure that we enhance the international law on human in general. I think that we definitely need, in addition to the one on the Convention on Refugees. In the case of Latin America, we had the Cartagena Declaration on peace, which is making 40 years this year. Many states are doing a lot of celebrations in this regard in Latin America, but the fact is that it's very unusual that the countries in Latin America actually make an effective use of the Cartagena Declaration. And we need to strengthen the international law on the issue of human mobility in general, so as to apply this situation to asylum seekers as well. As I mentioned before, in many situations, there are much more asylum seekers or would be persons who should be refugees than refugees as such. You can see, for instance, and I'm going to end up with this, you can see, for instance, the situation of Venezuelans around the world, and especially in Latin America, where about 6 of the 7 million of Venezuelans have moved. And despite the humanitarian crisis in Venezuela, the fact is that the rates of concession of refugee status for Venezuelans remain very low. And this is the case in the countries of South America, the case in the United States, the case in Spain, to mention the countries which are receiving the most Venezuelans. And I think this is representative for the situation in general. So there are many Venezuelans who remain as irregular migrants, really. And I think there is a big challenge to make sure that states take seriously the right to seek asylum and have persons who deserve that status getting it. Thank you very much.
Professor, thank you very much for your opinion and remarks. Thank you once again. And now I would like to invite Professor Denise Gilman from University of Texas. Professor, can you hear me?
I can. Can you hear me?
So Professor is on the faculty of University of Texas School of Law, where she co-directs the immigration clinic and teaches refugee law and policy. Professor received her undergrad degree with honors from Northwestern University and her law degree from Columbia University Law School. Professor has extensive research and practice experience in the human rights and migrants' rights fields. Before joining academia, she worked with the Inter-American Commission on Human Rights, Human Rights First, and the Washington Lawyers Committee for Civil Rights. She has been appointed by the President of the American Bar Association to the organization's Commission on Immigration for multiple terms and is a founding member of the board of the Texas Immigration Law Council. Is right? Okay. Once again, thank you very much for joining the session. And Professor, the floor is yours.
Thank you so very much for having me. I'm really excited to be with this gathering of experts talking about refugees on this important day. And while it's always a very significant challenge to follow on Professor Felipe González because of his wisdom and experience, I actually think that my comments might help to flesh out some of the very worrisome themes that he mentioned in the specific context of the United States. I thought that my most useful contribution might be to dig a little bit deeper and to share some of what our current experiences and realities are in the United States and potentially to think about some ways forward, some changes that could be made to improve protection for refugees and to help close the gap. I will note, I hope that we might in our discussion period talk a bit further about what Professor Felipe González just mentioned of the need for a more robust migrants' rights framework, because I do think that's exactly right. And it's part of the challenge that when we have a very well-developed refugee law framework and a less well-developed migrants' rights framework, then it creates a pressure first to distinguish between migrants and refugees, which we know is not so easily done because people have mixed motivations for migrating within any individual, and because it creates a situation in which there is a suggestion that those who are seeking to benefit from the Refugee Convention framework or the refugee framework are somehow engaged in fraud or trying to take advantage of the system, when actually it's just the case that there happens to be one system that's better situated to provide protection and another system that is less robust. And so there are reasons that make sense why people would seek to fit within the refugee framework. So in the United States, I think it is important to talk about where we are on refugee law, and specifically we mostly talk about it as asylum law. the law that governs determinations about whether somebody meets the refugee definition in the United States. I think it's important to talk about it because it's one of the main human rights issues taking place in the United States today, no doubt about it. And at the same time, what the United States does in terms of asylum seekers and refugees affects what is happening around the world, is both affected by and affects what is happening around the world, and so can contribute to worsening of human rights situations relating to refugees around the world, or potentially, theoretically, could lead to improvements if we could make improvements in our own system. Yet in the current state of affairs, there have been repeated concerns about the violations of human rights that are taking place in the US system, and it has been very difficult to transform that system to make it more rights protective. So a few notes about what our process is in the United States that are just helpful as background. So as I already mentioned, in the United States, when we talk about refugee determinations for people who are in the country, we talk about asylum. Asylum seekers are those who are seeking to be treated as refugees, and asylees are those who have been recognized as fitting the refugee definition. We use the term refugee in the United States mainly for those who are resettled from abroad, but for everybody who's undergoing any kind of refugee determination process in the US, we talk about that as the asylum process. The asylum process in the United States, for the vast majority now of asylum seekers, happens within an adversarial deportation process. So where you have the US government trying to deport somebody, and you have the asylum seeker facing deportation and presenting their asylum claim, their claim to refugee recognition, as a defense to deportation within that very same process that is before an immigration judge within the Department of Justice, all a very law enforcement focused apparatus with asylum kind of dependent on that enforcement based apparatus, and without any right to government appointed counsel for the asylum seeker in that proceeding. So you have the US government represented by its lawyers before an immigration judge, with the asylum seeker unrepresented unless they can find pro bono attorneys such as My Immigration Clinic or other private counsel paid for by the asylum seeker to represent them. In addition to this, which is already very exclusionary focused, very law enforcement focused, and not asylum focused, there are extensive screening procedures and other exclusionary procedures at the border, special proceedings at the border, which have become increasingly stringent in recent years. So many are excluded at the border itself, and they never really have the opportunity to present an asylum claim at all. For example, the most recent rule that you may have heard about that the Biden administration just adopted last week is exactly such a screening out rule that applies to those who present at the border or who cross and are found immediately after entering the United States. It imposes very high burdens on an initial showing of likelihood of a refugee claim. And if you can't meet that very high burden at the very beginning, you are simply deported immediately without any opportunity to actually present the asylum claim on its merits. So similar in some ways to other countries like Europe, particularly with the border screening apparatus. Pretty different from what I have seen, at least, and others can correct me, about Europe in terms of the way the asylum case goes forward if the person is allowed to present their asylum claim. I believe the US is pretty unique in having the asylum claim proceed forward from within the deportation process, with no pause of the deportation process while the asylum claim is proceeding. They go forward together. So what does this all mean for the current reality of asylum proceedings in the United States? There is a strong emphasis in the US on treating asylum as exceptional, an idea that there should only be very few numbers of asylum seekers, and then there should be even fewer numbers of people who are recognized as refugees through the asylum process. And this has really been the case since the very beginning of US asylum law. We adopted our main refugee law, asylum law, in 1980. And ever since then, we've tried really hard to keep the asylum grant numbers very small. It's never been more than 50,000 people in the United States recognized as asylees in any year. And the recognition rates are also pretty low, about 35%. And so this is without regard to the number of arrivals in the United States of asylum seekers, nor is it with regard to worldwide refugee flows. So as we've already talked about, there are over 100 million people forcibly displaced right now by UNHCR measures. And if you look at the UNHCR statistics, that displacement takes place in all regions of the world in very high numbers, higher than ever, at least since World War II. And yet the US asylum process keeps recognition of asylum at the exact same level over time, regardless of the flows and the realities of what's happening out there. This is without any explicit cap. It's just the reality of the way the asylum system has always worked. Is kind of the idea of the asylum system in the United States, and it's the practice of the types of mechanisms, the process that is in place ensures that the numbers are kept low. And you should compare these numbers under 50,000 asylum grants each year to other relevant numbers. In the United States, we do admit 1 million lawful permanent residents, new lawful permanent residents each year, green card holders. Every day at our US southern border, the Border Patrol admits, just through regular processes, about 550,000 people. And yet, for some reason, when we talk about asylum seekers, we talk about people who are coming without documents, previous documents, and they're looking to seek asylum. And when that number rises to 5,000 or 10,000 a day, there is a strong negative reaction, an action that suggests there is a crisis, that there is vast fraud taking place in the system. And that is because of this idea that we must keep asylum as this very minimal, exceptional kind of figure. So this creates a vicious cycle. We expect small numbers of asylum seekers and of asylum grants, of refugees to be recognized in the United States. And so we create processes that have that expectation in place that this is going to be exceptional. The numbers are never that small. They're always bigger. And so that creates this sense of crisis, as I say. And then we react to that crisis in the United States by putting in place new restrictive measures to try to get the numbers back down to what the expectations are. So the restrictive measures include fast immigration detention. About 40,000 people a day, again, are in administrative detention in relation with their immigration proceedings. We add new border exclusion measures. In recent years, it's been everything from, as you all know, family separation to the Remain in Mexico program, sending people back to Mexico to wait for their proceedings, to Title 42 exclusions, where people were just sent back out of the country without regard to any asylum claim based on supposed public health considerations. And these border restrictions include other measures such as the new Biden measures that put a much higher screening requirement in place before people can even present their claims. Then we go back to the vicious cycle because those new restrictive measures still don't stop the flow because of worldwide trends and because of the human rights situations in people's home countries. And so the numbers continue to rise. We react as though as this is a surprise, that we are unprepared for it because we put in place all these restrictive measures that don't work. And so the reaction, rather than questioning whether the restrictive measures are the right approach, is to put in place even more restrictive measures. And so we get into this vicious cycle. And then this creates serious problems. So one of the consequences of this vicious cycle of treating asylum arrivals, asylum seeker arrivals as a crisis, as excessive, one is that in our effort to keep the numbers of asylees low, the US system engages in national origin discrimination. Basically, those countries that are nearby us and that send large numbers of asylum seekers are treated as not being valid asylum seeking countries. And so it's very difficult for asylum seekers from Latin America to gain recognition. And instead, we grant asylum at a slightly higher rate, to those who come from much further away. China is the country that has had the greatest number of asylees recognized by the United States throughout our entire history since 1980, and in higher percentages. So both higher numbers of just actual people recognized from China and at much higher rates than everywhere else. Whereas Central American cases are recognized at much below average rates. This is discriminatory and also creates the idea of the refugee as other. It both depends on this idea that the refugee must be, from far away, very different from what we're used to in the United States. And then by only recognizing those who come from far away, it creates the refugee as other and reinforces that, which is a negative consequence of this national origin discrimination that is racialized as well, I should note. There are other consequences. It means that many people are denied protection in the United States, resulting in human rights violations. As Professor González already mentioned, we have an obligation not to return people to danger, but that's what's happening when we don't, when we refuse to recognize those from coming nearby as being valid refugees. It creates legitimacy problems for our asylum system, which then means that it's even less likely that people will sort of abide by the expectations of who will be coming and in what categories. It creates cycles of danger. It means that organized crime has strong profit centers at our border where people are being excluded regularly, making it harder and harder for people to cross. So then cartels can charge much more and engage in much greater violence against vulnerable asylum seekers at the border. And the kind of discriminatory way in which we carry out our asylum process also creates integration issues, because it means that we are accepting as refugees only those who are coming from further away with different languages and different realities, and so therefore challenging for integration. Not impossible. We can definitely do a better job at it, but I think it's fair to recognize that it makes the burden of integration greater. And it requires basically refugees to travel further. And if we think that it's not just the United States doing this, but other countries of the world as well, then it means that if Spain is recognizing people only from further away, and the US is also recognizing people only from further away, then you're pushing people to travel broad distances in very dangerous circumstances. So I've talked too long, so I won't go into, we can talk later about some ideas for change, but I think essentially we need to streamline our proceedings, but not towards elimination of due process for those who need it, but streamlining towards inclusion, towards greater recognition of greater numbers of refugees as asylees more quickly, relying on group-based determinations and less complicated proceedings that are time-consuming and resource-intensive rather than refugee recognizing. Thank you for this opportunity.
Thank you very much, Professor, for presenting this US perspective. It was great because in the first speech, Professor Felipe González Morales, we had some general view. Your perspective, it was US perspective, and now we will have European perspective, because I'm very happy because next speaker will be Professor Anna Potyrała from Adam Mickiewicz University in Poznan, Poland. Political scientist, lawyer. She works in the Department of International Relations, Faculty of Political Science and Journalism on my university. And frankly speaking, Professor is my boss, because she is Associate Dean for Academic Development and Internationalization on our faculty, and she conducts research in the field of involuntary migration, international criminal justice. This presentation will be titled "Particular Solidarity as EU Member States Approach to Migration Refugee Crisis." Professor Anna, the floor is yours.
Thank you very much. First of all, I would like to thank for the invitation for this panel, especially today during the International Refugee Day. Thank you. I would like to thank both previous speakers for kind of an introduction to my presentation, because Professor Morales, he addressed some general problems, some general issues which we witness today when we talk about refugees, when we talk about the international system of refugee protection, while Professor Gilman focused on this American perspective. As Professor Skrzypczak said, I would like to tackle the problem of the European Union and its attitude towards refugees. However, I don't want to analyze the European asylum policy. I don't want to analyze during today's presentation. I don't want to analyze the European migration policy, but only to tackle one, in my opinion, crucial problem of the so-called particular solidarity, which we witness among member states, which we witness in activities of the organization as a whole. And of course, when we talk about this particular solidarity, we must focus, we must actually go back to the beginning of the debate, political debate, but also social discussions which are still being observed in European societies since 2015. The whole debate and the exchange of different points of view influenced and still influence activities of the European Commission towards refugee question. But what's the most pessimistic is that the whole debate, which started in 2015, was aimed not at improving the system, not at improving migration and asylum policies, but first of all, it resulted in some kind of a selective interpretation of human rights protection and refugee protection. And secondly, it also resulted in a change of perception of solidarity as one of crucial principles of European activities, principle which is mentioned in the treaties. In 2014, declarations about almost absolute need to protect refugees and persons in a similar situation dominated the European debate. However, 1 year later, in 2015, some kind of a shift of statements, shift of attitudes was observed. The whole process of designing new regulations within asylum and migration policies of the European Union started because of the crisis. Because of the crisis which in 2011 had totally refugee character. In 2014, it started to be perceived as a migration crisis. But as a result of this kind of intensified pressure, as a result of this migratory flow which was observed in 2014, the European Commission proposed a special relocation system. Which was actually about sharing responsibility for persons arriving to the European Union. But despite its formal approval, a clear split among member states could have been noticed, and the myth about European unity, about European solidarity towards challenges, towards threats, well, actually has been debunked, and conflicting interests have become more and more visible. Of course, and that's a pity to say, I'm from Poland, but the biggest mobilization was shown by the so-called unwilling coalition, composed of Poland, but also Hungary, the Czech Republic, and Slovakia. All these states, they opposed the idea of sharing responsibility for persons arriving, as well as the possibility to grant protection to those arriving persons. Each and every of these countries, first of all, initiated revision of domestic regulations. For instance, making it impossible to request to lodge applications and request for international protection by persons coming from certain countries, from certain directions. Border controls have been reintroduced, the border fences have been created, referenda have been organized. Everything concentrated on this main task, which was to guarantee security of borders, security of territories, and in other ways not to allow foreigners to come to those countries. And the problem was that month by month, new member states decided to join this club, insisting on reforms of EU migration and asylum policies. But as I said before, reforms which were not aimed at improving the system, but at protecting external borders, at protecting EU territory from any kind of migratory pressure. And for this reason, what we have today within the European Union is what I call particular solidarity, or self-centered solidarity. This approach actually occurs in all new proposed regulations. It is also visible in the European Pact on Migration and Asylum, because on one hand, all member states are legally obliged to guarantee the possibility to lodge asylum applications. So all persons in need of international protection, they should have the right to apply for asylum. But on the other hand, state interests are at stake. Interests which very often are characterized in a fundamental manner, so they are treated as national interests. And in a situation like this, when we talk about state interests, they will always be given priority over human rights, over migrant rights, over refugee rights. Of course, there are many declarations within the European Union about protection of fundamental rights of migrants and fundamental rights of refugees. Among them, for instance, the need to standardize asylum procedures, the need to provide immediate assistance to minors, or to introduce some kind of monitoring mechanisms. But still, the key element are joint actions aimed at assisting hosting states, those member states who experience migration pressure. And the task defined in the pact, in the European Pact on Migration and Asylum, is most of all to guarantee rights and to preserve interests of member states, not of persons who migrate. So the primacy is given to states' rights. And even all these new initiatives which are being introduced by the European Commission, for instance, global partnerships with Egypt, with Tunisia, with Mauritania, they are also in practice aimed at safeguarding EU member states' interests, not these of refugees. And the same must be said about these infamous hotspots, reception centers located in third countries. And of course, such perception of migration flows and refugee flows as threats to peace, to security, to stability in different states and regions, and even in a global manner, it is nothing new, because it revealed in the interwar period. If we remember the 90s, Sadako Ogata, the then UN High Commissioner for Refugees, she actually warned that the main reason for inability to resolve refugee question was unwillingness of states to fulfill legal obligation. States which, because of social, because of economic or political reasons, refuse to share responsibility. And that's what we see today within the European Union. The main aim of any regulations, the main aim of any actions is to stabilize situation in member states, especially those which experience refugee pressure, and not to protect persons in need. Therefore, we are today witnessing, we are observing, well, it must be said, total change of perception of the concept of solidarity. Today, solidarity is not perceived as it should be, as, for instance, responsibility to fulfill international legal obligations towards refugees. It is not perceived as a moral obligation to protect human lives, but as a strong desire to act in concert to realize aims, to realize crucial goals of member states. So solidarity in the European Union means joint actions to provide assistance to member states, not to persons in need. There are, of course, different factors determining such perception of solidarity. In my opinion, among internal determinants, primary place should be given to public opinion. For instance, today, one of main Polish newspapers published results of a survey focusing on Polish attitudes towards foreigners, not only refugees, but foreigners in general. And according to this survey, 42% of Poles, they refused the possibility to accept foreigners in Poland, in Polish territory. Out of those who accept, 35% would like to see in Poland only foreigners from neighboring countries, so Ukraine or Belarus. Only 14% of Polish respondents accept the possibility to let in persons from far located states. Among external factors, on the other hand, I think those international interdependencies play decisive role. But of course, those both groups of factors, they result in this new way of perceiving solidarity as cooperation aimed at protection of particular interests. So consequently, today, the international community members decided to return to the idea of Emir de Vattel, who at the end of the 18th century insisted that exchange of assistance between nations, between and among nations, is crucial, but at the same time, each nation must give primacy to its own interest. So as a result, what we see in the European Union, when we look at new proposals, at new draft regulations, we see that such well-developed concepts as human security, as responsibility to protect, today they are interpreted in a very narrow way. They refer only or almost only to the European Union citizens. The whole concept of the area of freedom, security, and justice is actually tailored to the needs of citizens, of the European citizens, not of all persons who enter the territory of member states. So, of course, we must remember that in the Charter of Fundamental Rights of the European Union, we have the right to asylum. It is guaranteed, but it is defined only as the right to claim for protection, to request for protection, not to receive it. First, we must remember about that, and secondly, if such a guarantee is written down in the Charter, we must remember that in practice today, even this right, the right to request for protection, is being denied. It's when we look at the situation at the Polish-Belarusian border, this is the problem. And the second aspect, the second problem, even the right to be protected from expulsion, which is also guaranteed in the European law, which is confirmed by judgments of, for instance, the European Court for Human Rights. Even this right to be protected from expulsion is at risk today. And of course, the problem which is visible, I think, in the United States, in the European Union member states, and in many other countries, this is this dispute or even conflict between sovereignty rights, state sovereignty rights. So, for instance, the right to decide who can enter the territory of a state, and on the other hand, refugee rights. None of those rights is regarded as a fundamental right, even though we would like to, and of course there is this very long-term discussion about non-refoulement. Is it a jus cogens norm or not? But still, there is no consent concerning this problem. Thank you very much.
Thank you very much, Ania, for this European perspective on the situation of migrants and refugees. I should say I'm sorry now, because I promised that after the three speeches we will have the question and answer session, but I would like to ask you for a small change in our agenda, because as I can see, Alexander Pires from Lisbon University has joined to this session. And so if, yes, Alex, can you hear us? Can you see us? I hope yes, but I'm afraid that you don't have, yeah? Okay.
Yes.
Excellent. So I'm very happy that you have joined the session. So very shortly, Professor Alexander Xavier Pires is from Lisbon University, has a double doctoral degree with a PhD in legal and social science, with doctoral studies in European constitutional justice and human rights. And professor is also chair-elect of RC26. So your speech will be about migratory flows, humanity and peace, yeah?
Yeah.
And question and answer session will be after your presentation, okay?
Okay.
Okay, so the floor is yours, okay?
Thank you. Thank you very much, Professor Jędrzej. Greetings and good afternoon from Lisbon. It's an honor to participate in this webinar on such a relevant and important topic for the direction of humanity. Congratulations on the RC26 initiative. Colleagues, I intend to be brief in my speech. When I received the invitation from Professor Jędrzej, chair of RC26, whom I congratulate on his work, I saw the opportunity to update the topic presented at the Latin American Social Innovation Network took place in Panama City in 2017, entitled Intercultural Mediation Instruction Centers dedicated to social inclusion and professional training, inspired by the values of work and respect between equals, guaranteed by education in the light of international cooperation to solve the migration crisis. On that occasion, it was proposed that intercultural mediation based on the values of education dedicated to democracy should serve as an instrument for bringing migrants closer together, whose category included refugees and displaced persons, considering that the concern was not only to welcome them, but also to integrate them into society. The focal point of this model were reception and integration centers as an alternative model for linking civil society and the government, facilitating dialogue between the host people and the migrants. The weak points were debated, and one of the most tense issues was addressed at the 10th World Congress of Constitutional Law, organized by International Association of Constitutional Law in Korea, under the title Culture of Peace and Constitutional Challenge, a proposed focus on the intercultural mediation in criminality prevention. With the social and political system determined in the legal reception within the framework of constitutional law, a scientific article was published in the scientific journal Galileo, entitled Forced Migratory Flows and Culture of Peace, a hypothetical contribution based on education as a pillar of democracy and an alternative solution to the crisis for the welfare state in 2019. The paper proposed a conclusion preparing the practical part of the model, which unfortunately was never implemented, but here is the last notes. This is a provisional conclusion. In view of the initial stage, the model has reached, as well as the intention to theoretically formulate the project in the light of the normative reading of the United Nations General Assembly resolutions at the current section, tended to converse the rereading of education and the reduction of public costs with the solution of the crisis of welcoming immigrants and refugees, with the framework of the reconstruction of democratic values that guarantee the rule of law in an environment of a culture of peace that admits dialogue and tolerance, especially a restricted cultural respect for and between all. We risk proposing just one question. Wouldn't the center of instruction system that embrace the sense of democracy focused on education with the sedimentation of the principles of the social values of the work transposed on a moral level and the respect between equals in a reading of dialogue and tolerance to be managed by intercultural mediation that brings individuals together allow at the same time the contribution to the solution of the crisis of forced migratory flows, the strengthening of the actual agenda for sustainable development in terms of socio-economic, legal, and political insertion, and the strengthening of the rules of international law on reception and repatriation. This project, as I said, was never put into practice, largely due to the pandemic that accelerated the economic crisis, social instability, and the resumption of the historical wars that raised international tension. However, on a positive note, and this is the justification for my speech today, I was particularly happy and hopeful because much of what was criticized and suggested in 2007 has become international reflection and become part of the movement to raise awareness and establish legal certainty, as can be seen in the resolution 217 of the current session of the United Nations General Assembly, adopted on 23 December last year, on the title Protection of Migrants. Resolution 207 on the protection of migrants is extensive, dense, and complex, allowing for countless considerations and reflection, as you can already see. For my part, I would like to point out that migratory flows are as old as human beings. They mark the very history of mankind, which on one hand should already have a defined and regulated treatment, overcoming demagogic phenomena, such as the defense of nationality to preserve sectarian public policies, and the discourse of protection of local culture to restrict multiculturalism. This point should have already been replaced by the true discourse that we are all equal but different. Equal because we are human beings, wherever we are, and different because we want different things. And it's precisely the common condition of being human that allows us to speak of humanity. Here I recognize the importance of the proposition, on the one hand, about the freedom of movement and freedom of residence without restriction of borders, and the legal and the equal condition of everyone being a person, as stated in the preamble of the resolution, reaffirming also that everyone has the right to freedom of movement and residence within the borders of each state, and that everyone has the right to live in the country, including his or her own, and return to his or her country, and after, entirety, that everyone has the right to recognition everywhere as a person before the law. Furthermore, seeing migrants for their social, cultural, and economic contribution from the perspective that it is knowing the other that we realize the line created by the culture of conflict. It is knowing the other that we can see how equal we are. It is by knowing the other that we can respect what they want differently for us. In short, migratory flows bring peoples closer together, encouraging dialogue, tolerance, and respect between equals. The preamble to Resolution 270 is therefore to be congratulated when it is stated the cultural and economic contributions made by migrants to their communities of origin and destination and the need to identify appropriate means of maximizing development benefits to respond to the challenge that migration poses to countries of origin, transit, and destination to promote dignified human treatment with applicable protection and access to basic service, and the strengthened mechanism for international cooperation and more, recognizing that migration can increase social, cultural, and economic ties between nations and can be facilitated by agreements with regional integration process to reinforce education exchange, labor mobility, and the portability of applicable social security entitlements and the earned benefits of migrant workers. Despite this development, the simplistic approach of respecting the right of state to sovereignty over migration policies deserve attention. However, this reflection will be left for another occasion due to time constraints. Furthermore, the loss of opportunities to link the protection of migrants to a culture of peace is regrettable. In fact, only break with the culture of conflict by raising awareness of a positive light without violence and for peace can guarantee the effective protection of migrants. Even without mentioning it, it is possible to see that the elements of the culture of peace are indirectly present in accordance with the guidelines of the Resolution 243 of the 53rd section of the United Nations General Assembly. In particular, the bringing together of people without the territorial limitation of states guided by tolerance, respect, and dialogue. Education as an instrument for guaranteeing and strengthening measures to protect migrants. The idea that it's by getting to know the other person that we can break the handcuff of lies built up by the culture of conflict. And it is think and talking about peace that the culture of peace is strengthened. Much more should be said, but time does not permit. I hope that I hope I have been clear and at least emphasized the importance of peace in understanding the welcome Resolution 270 on the protection of migrants. Thank you very much for your opportunity and for your attention. I'm sorry, but I have to leave for academic reasons. Professor Jędrzej, I take the floor back.
Thank you very much, Alex, for your speech. I discovered that in main part of our meeting we have speeches and now we will have a discussion, questions and discussion, but I can see that we have also a very interesting discussion in chat box. Professor Gilman, thank you very much for your remarks about the success stories. And if you would like, everyone would like to access to this discussion, of course, this is open for everyone. But as I promised, now this is first before the second part of our webinar. Will be the questions and answers session. Oscar, so may I ask you to conduct this part of our webinar?
Okay. Yes, I will be the discussant of the session, and I would like to address my first question to Felipe González, who has been the first speaker, and I would like to ask him. Well, it was very interesting his approach to the question from his experience, as rapporteur of United Nations for migrants. And it was very interesting, the different regulation and the different impact of migrants and refugees. And my question for him is, if the law recognition of the refugee status that usually happens, for example, in Latin America, is something that breaches the enforcement of rights, and what are the realistic alternatives? I think it's difficult, but I think, of course, refugee has a lot of regulations, international regulations, but there is a low recognition, low-level recognition of this status. And then I think the change of mind should be general about the refugees, the asylum seekers, and the migrants. It should be a general change, more general than, in order to enforce the rights. I make all the questions? I asked all the questions?
Yeah, sure.
Okay. To Professor Denise Gilman, it was very interesting, the U.S. framework, all the what she mentions. I was really surprised because there is only, if I have understood well, there is the recognition of 50,000 asylum recognized per year in all United States, and every day 50,000 people came from the southern border. This means that in one day, it came to United States what is recognized in the asylum, as asylum seekers. And of course, there are there are differences between migrants and asylum seekers, but for the question of quantities is. My question for her is, it was very interesting when she says that, for example, asylum seekers are not recognized if they come from Latin American countries in general terms, but are recognized from China. And my question is, there is a foreign policy, is a question of policy, foreign politics, the asylum recognition, or is a question of human rights, or it's a political conception of human rights that are behind the recognition of asylum. My question for the Professor Potyrała, sorry for my pronunciation. It was very interesting, the European approach. There is very controversial, the European agreement, the European Union agreement for migration. It has been very controversial from the point of view of the NGOs of migrants. I like to know, I am interested in your opinion, your personal opinion about the European Union politics about migrants. What do you think? And you mentioned the public opinion of the countries, and I think this is a crucial point, and it's very different, and it's interesting because here we are people from different countries, and in different countries we have different public opinions, left wing, more right wing, or extreme right wing in some countries. How do you think this is related with the policy of the country in terms of asylum seekers or migrants, no? The general policy of asylum seekers and migrants. And my question for is not here.
Alex, yeah, maybe the question to Alex on chat, okay?
Yeah,
so
okay.
He apologized, but he had to switch on.
I know. Okay.
Okay.
Okay, thank you very much. It was really, really interesting, all your interventions.
So should I start?
Yeah, sure,
Yeah.
please.
Okay. Well, thank you very much, Oscar, for the questions. And I would say that during my tenure at the reportership, and I think this has been a consistent policy, we address this issue in a we try to have a realistic approach, and of course we were pushing forward to make sure that asylum seekers get the opportunity to lodge their applications and to get the refugee status when they deserve it. But as you say, this becomes very difficult in many countries, and this has been described by the different speakers here and by myself. So we also at the reportership, and this is my personal view as well, we also promoted wide processes of regularization. As I said before, and in my presentation, there are many persons who would deserve refugee status, but for different obstacles that they are presented to lodge their complaint, their applications, or going through the procedures, they remain as irregular migrants. So we have at the reportership, we encourage states to adopt regularization processes. And I think that in the case of Latin America, the best example in this regard is Colombia. Colombia is the country which has is a neighbor country of Venezuela, as you know, and is the country which has received the largest percentage of Venezuelans. About 2 million or 2 million something Venezuelans have arrived in Colombia, out of 7.7 Venezuelans or so that have left their country for the last 10 years. So, and Colombia a couple of years ago adopted a wide legislation to regularize Venezuelans. This is been done for a 10 years period, but it is expected that after that time they might be able to get a permanent residence permit. And in fact, the problem is that this does not apply to persons coming from our countries, but that was an important issue. And here in Spain, where I'm these days, there is also this large discussion about potential. I mean, there is a discussion at Parliament at this point, Congress, about a regularization process that would benefit 500,000 persons. You can see that this kind of regularization processes have become less and less frequent. In Spain, the last one took place in 2005. In the United States, I understand it took place in 1986. Despite the fact that both Spain and the US, as other countries, also regularize persons on an individual basis, achieving large numbers. But using regularization as a to address the situation of persons who are not able to either lodge an application for refugee status or to achieve that status, I think is a way to try to make their situation more livable and that they can enjoy their human rights.
Thank you very much, Professor. So maybe time for the answer from Professor Gilman, okay?
Thanks. Yeah, no, super helpful to have the dialogue to be talking about these themes. So quick clarification, the 500 and it's 550,000, not 50,000, that are processed at the southern border of the United States every day. So 500,000 people. That would be anybody in the normal course of processing. So that could be US citizens who are just coming back and forth. It could be people, there are people from northern Mexico who have these border crossing cards that they can just go regularly. It could be people with visas to come as tourists, and it could be lawful permanent residents who are just going back and forth with their green cards. But the point that I'm trying to make, which is I think is the one that you took away, Professor Pérez de la Fuente, is that if we can process as a matter of course 550,000 people at our border, and we have the apparatus set up for that, then why can't we process a reasonable number of asylum seekers who are arriving without documents, without doubt, by their very definition, but who in large numbers will have valid claims to protection. And then, yes, in terms of how many we grant asylum to, we only grant under 50,000 a year. If you compare that to the 550,000 that we process at the border every day, or the 1 million that we grant green cards to, lawful permanent residency to each year, you can see the very restrictive nature of the asylum recognition process. And that dovetails with your other question about why so many more grants to those from China as compared to those from Latin America. Politics, foreign affairs certainly plays a role still, but I don't think that's the full explanation, particularly when you consider that the United States has a pretty strong policy foreign affairs stance, for example, against Venezuela or even against Nicaragua, and yet we don't grant asylum at the same rate as that which we recognize for those from China. So that's not the full explanation. I also don't think the full explanation is that these are just better fits with the refugee definition for those who are arriving from China, and therefore this is a genuine kind of human rights filtering that's happening, and we're granting asylum to those who best fit the refugee definition. I think many cases from Latin America do fit the refugee definition perfectly. I think that it really does have to do with this idea of asylum as exceptional, that it should only be a small number of people from very far away, very other from what we perceive as being sort of part of the normal cultural landscape, political landscape of what we're accustomed to in the United States. And so we do, for example, I gave China as a quick specific example, but we do also grant more cases at a higher rate from African nations such as Ethiopia, Eritrea, Sudan, and others much more easily than we do for Latin America as well. And so I think that fits with this overall idea that I do believe is really problematic of only understanding as refugees those who are very other from us, because I think that has significant consequences for then a whole set of issues around integration and then around how we treat refugees worldwide. I think we would be all much better off if we could see those coming from countries near or by as being valid refugees, if all nations were able to do that.
Thank you for your answer. And now, Professor Anna Potyrała.
Thank you very much. As to the first question about my private opinion concerning policies, migration and asylum policies of the European Union and the European Pact on Migration and Asylum, yes, it is controversial. Yes, it has been criticized, especially by NGOs and by human rights advocates. Should we criticize it if we, for instance, take the stand of countries? Well, it's extremely difficult to meet expectations, expectations of both sides, as very often they are colliding. So it's extremely difficult when you have on one hand arguments of state security, security of borders, security of territories, security of citizens, and on the other, security of those coming in or those who would like to enter. But of course, if you ask me, I would say, and I will say, if all member states of the European Union are state parties to the Geneva Convention of 1951 and the New York Protocol of 1967, those provisions, those legal obligations, international legal obligations, they should be treated seriously, so they should be fulfilled. Therefore, if we create a system based on the European law, it should be in accordance with international legal obligations. And all these, of course, because today we are criticizing the pact, but please remember that this critique of the European approach towards migration and the issue of refugees started in the 90s, when the European Union introduced this, for instance, safe country concept, when the European Union started to initiate discussions which ended in directives, in adopting directives on different kinds of subsidiary protection. So on one hand, we may treat it, okay, we are trying to guarantee protection for those who do not meet standards defined in the Geneva Convention. But on the other hand, we may say, okay, we are introducing new additional forms of protection, which actually is aimed at, all these forms are aimed at not giving refugee status to those who really deserve this international protection. And the second question to this perception of refugees and migrants by public opinion, I will use the Polish example of 2014 and 2015. In 2014, about between 36% of Polish citizens were against the possibility to invite or to accept refugees in Polish territory. When the government changed in 2015, suddenly all surveys showed that we have about 70% of those who opposed this idea. Why? Because of this whole governmental narrative, which was proposed by official members of the government, which was given by ministers, which was given even by prime minister, by the leader of the main Polish party. So. Yes, I think that there is this strict connection between the official governmental narrative, which is given, and public opinion perception of foreigners and also refugees. Thank you.
Ania, thank you very much. And now the time for the second part of our webinar, and we have two excellent speakers and brilliant speeches. First will be Professor Cláudio Cornélio Bezerra Pinto Coelho, professor who is a lawyer, professor and writer, chairman, among others positions, chairman of the Compliance and Governance Committee of the Brazilian Lawyers Institute, Vice President of the Ethical and Compliance Institute in Portugal, Vice President of the Ethical and Compliance International Institute based in Portugal, Director of the Law School of the Brazilian Lawyers Institute. And so Professor proposed the speech, the Venezuelan refugee crisis and its repercussion in Brazil. Professor, the floor is yours, okay?
Thank you very much, Dr. Can you hear me?
Yeah, excellent.
Okay.
Very good.
Thank you very much, Dr. JJ. And don't worry, because the pronunciation of my name is Perfect. I would like to share my presentation, but let me see if I can. It's okay?
No. Yes, maybe now, but yeah, we can see now.
Yeah, okay, thank you. First of all, I would like to say that I feel very happy and honored to be part of the Research Committee 26 and of the International Political Science Association, and especially to take part in an event as important as this one, which address a topic of extreme importance for world society. I would like to congratulate Dr. Jędrzej, Dr. Oscar Pérez, congratulate my friend Dr. Alexander, and congratulate the other researchers and speakers at this event. The humanitarian crisis in Venezuela has caused millions of Venezuelans to leave their country in search of decent living conditions. The migration of Venezuelans was motivated by the crisis scenario experienced in Venezuela, which since 2013 has faced instability in the government, causing political, economic, social, and institutional cause. The lack of jobs and basic resources for survival has resulted in a situation of this sad scenario has led thousands of Venezuelans to leave the country and migrate to other regions in search of better living conditions and job opportunities. In this context, one of the main destinations chosen by immigrants was Brazil. According to data from the federal government, since 2018, when the Brazilian government began good reception operation, in Portuguese, Operação Acolhida, to answer to the huge flow of migrants from Venezuela. Thousands of Venezuelans have migrated to Brazil by November 2023, making the country the fourth largest host nation for Venezuelans, behind Colombia, Peru, and the United States, respectively. Let's look at the two graphs below. These were the last official data cataloged in Brazil, so we don't have a new data in 2024, okay? But here we can see Brazil at the third position. So this data was, as I said, this data was cataloged in 2023, but by May of 2024, it is estimated there that more than 1 million Venezuelans had entered the country, the vast majority through the city of Pacaraima in Roraima. As a result of this intense migratory flow, problems have arisen in Brazil, as the majority of Venezuelans have settled in just one state, Roraima, which shares a long border with Venezuela. This is because the Venezuelans enter Brazilian territory through the state of Roraima, and more specifically through the city of Pacaraima, which has a big area, as you can see in the slide, and until then had a population of just over 20,000. So you can see and imagine the impact of this sudden increase on the city's population. This problem has led to a collapse in several areas, especially in the face of the overload in the state's public service, which have not been able to cope with this new demand on their own. According to local news reports, this had led to an increase in the number of traffic light beggars, whether beginning or selling food, improvising stalls, and also an increase in the number of policy incidents involving prostitution and crime in general. In addition to the reception post, the program called Good Reception Operation has shelters and internalization posts, a strategy to reduce the pressure on the state's public service and integrate immigrants into the job market in different parts of the country, since Brazil is a country of continental dimensions. Although Roraima is unable to house these immigrants, the number of Venezuelans does not exceed Brazil's capacity to absorb them. Since compared to the other countries, such as United States and Canada, Brazil has a lower number of immigrants than its capacity. Only 1% of the Brazilian population is made up of immigrants. The world average is 3%. The problem is the current concentration of Venezuelans in just one state. On the other hand, receiving immigrants without the necessary planning has resulted in social impacts, such as the vulnerability of Venezuelans who are subjected to a reality of poverty, hunger, and the worsening of diseases, and in some extreme case, xenophobia. However, the help of volunteers, such as Brazilian billionaire Carlos Wizard, has made a difference in humanitarian aid. The main work he does in Roraima is related to internalization of Venezuelans. He heads a group of volunteers who transfer newly arrived immigrants to other parts of the country and also find jobs in the destination cities. Since April 2018, his group has taken 25% of the total number of the Venezuelans internalized by Operação Acolhida, created in February 2018 to deal with the migratory flow of Venezuelans in Roraima. The trips have been made on commercial flights at zero cost since last year, thanks to an agreement he made with Latam, Azul, and Gol Company, which provides for the use of unoccupied seats. Let's look now at some interesting data on the migration of Venezuelans in Brazil. So here we can see the profile of Venezuelans distributed among the Brazilian states. We have in Brazil, Brazil has more than 5,000 municipalities, or you can say cities, to compare with another country. We have here more than 5,000 municipalities, and a little bit more than 1,000 receive Venezuelans refugees. Another slide, you can see the main cities that received Venezuelan people, immigrants. So I think that you don't know what is Curitiba, Manaus, São Paulo, Chapecó, and Dourados. So I did another slide, and here you can see better. The problem is, here is Venezuela, and here is the state that means Roraima. And this city, as I said, Pacaraima is a city who has 20,000 inhabitants. So in 2024, Brazil received more than 1 million Venezuelans. So you can see here the distance from the Roraima and the south of the country. And you see in the last slide, Curitiba, Manaus, São Paulo, Chapecó, Dourados, the cities is in the south of the country. So the distance to be here is more than 10,000 kilometers, and is most expensive to be here. So they can, the government must help them to come here, okay? And the population of Brazil is more than 2,200 million. So it's easy to receive all of them. Here we have the number of trips within Brazil per year. What I said, we don't have the official catalog, the 2024, but here we have the official data until 2023, number of trips within Brazil per year. And here we have a breakdown by gender and breakdown by age. Male 53% and female 47%. And here 61% over 18 years old, and here under 18 years old. I prepared these slides to make it easier to visualize the Brazilian scenario with numbers, distance, and population data in order to see the reality of the migration of Venezuelans in Brazil. So I finished my presentation and say again that it was a pleasure for me part of this important event, and thank you so much.
Thank you very much, Professor, for your presentation and information from Brazil. Let's jump from Brazil to Poland, and I'm very happy because I can invite to this webinar Magdalena Bartosiewicz, attorney at law in Warsaw. Magdalena Bartosiewicz is also chair of the Commission for International Cooperation and Human Rights, National Council of Attorneys in Law in Poland, but she was awarded by National Chamber of Legal Advisors in Poland special award, Crystal Hearts Award, which she received for supporting and coordinating aid to war refugees during last years in Poland. She is head of the Refugee Legal Aid Coordination Center of the National Chamber of the Legal Advisor in Poland. So once again, I'm very happy that Magdalena is together with us, and I hope that she will share her experiences and remarks about the life on the border during the wave of migrants in Poland. So can you see us? Can you hear us?
Yes, of course. Thank you, Professor, for introducing me. I have
know
also
that you have presentation, yeah? So
yes, I do my best to wait a moment.
Presentation, okay.
Okay, to present it, please. Do you see it? Maybe it's okay.
Yes, now we can see. Yeah.
Okay, so maybe this is better. Okay. So if everything is visible, I think I can start. Good evening, good afternoon. I warmly welcome all the persons who are with us today at the webinar. I am extremely pleased to be able to meet with you. I am also very honored to appear today among such distinguished speakers who are sharing their experience with us. I was asked by Mr. Professor Jędrzej Skrzypczak to provide you today with a general overview of the current situation of refugees and migrants in Poland. This situation, I must admit, is very intense and complicated. I will divide then my presentation today into two parts. Yes, one concerning the situation on the Polish-Belarusian border, and the other concerning people from Ukraine in Poland. The situation of those two groups of foreigners in Poland is drastically different and is accompanied by a completely different public discourse. So maybe let's start from numbers. As you can see on the slide, the number of persons applying for international protection in Poland in 2023 was 9,513 people. Not much, I think. The three main nationalities of asylum applicants were Belarusian, Ukrainian, and Russian. Belarusians had the highest overall recognition rate with 98% positive decisions in 2023. And these individuals crossed the border in the vast majority in what is known as a regular manner. The remaining countries whose citizens applied for international protection are Turkey, Egypt, Afghanistan, Tajikistan, India, Syria, and Iraq. A total of 1,178 applicants filed their applications. Of these persons, 250 persons were granted refugee status or subsidiary protection in Poland. In this case, most of these people are those who have managed to cross the Polish-Belarusian border and file an application for international protection in this irregular manner, yes. Not much if you compare it to the general number. Access to Poland through its border with Belarus is still the main problem. Testimonies collected by civil society organizations for 2023 include reports on the use of verbal and physical violence by officers of the Polish border guard and other forces.
I'm sorry,
Yes?
Magdalena, because we still see the first slide. Could you
The first and then?
Or maybe you can switch on the mode full screen. Okay, now, yeah.
Okay, it's better? Okay.
Yes, now it's okay. Yeah, but can you switch on the full screen mode?
Okay, and now? Yes, I did it. I already did it, and yes, okay.
Yeah, okay.
Okay, so thank you for your comment. So once again, as I mentioned, access to Poland through its border with Belarus, this is a main problem at the moment. So according to testimonies collected in 2023, there were a lot of situations of using of verbal and physical violence by officers of the Polish border guard and other forces towards migrants who seek access to Polish territory. Until the end of January 2024, the European Court of Human Rights communicated 11 cases concerning pushbacks at the Polish-Belarusian border. The applicants invoke, among others, violations of Articles 3, so prohibition of torture, and Articles 13, right to an effective remedy. Of course, I am talking about the European Convention on Human Rights. The applicants also invoke Article 4 of the Protocol number 4 to the European Convention, so prohibition of collective expulsion of aliens. Okay, I have already changed the slide. Mr. Professor, do you see it, maybe? The current
still
problem?
second
Yes?
slide. Still
okay.
second slide.
So once again.
Okay, now, yeah, the third one. Yeah.
Okay, I have no idea what's going wrong.
Okay, now it's okay.
Yes, it's okay? Okay.
Yeah.
So the humanitarian crisis at the Polish-Belarusian border that started in 2021 and continued until today left many prospective asylum seekers without any or without proper access to material reception conditions, including medical assistance. At least 60 persons died on the Polish-Belarusian border, while many others suffered injuries and other health problems that were not sufficiently or at all treated. Children with families are still detained on a regular basis, and the best interest of a child principle is commonly not taken into account in court proceedings. No identification system for victims of violence is in place, and victims of torture are still in practice placed in detention centers, despite the binding regulations prohibiting detention in these kind of cases. It's obvious that Belarus facilitated irregular migration to the European Union in response to the European Union sanctions in 2021, but at the same time, Poland refuses to provide access to asylum procedures to those in need. The border guards started carrying out pushbacks by immediately sending back to Belarus those who managed to cross the border. In this context, national law was amended to include rules that would facilitate collective expulsions, which are still in force today. Doctors Without Borders also confirmed that throughout 2023, the doctors treated, I mean the members, yes, of the organization, treated injuries and harm caused to migrants who were pushed back at the Belarusian border. According to them, the over 5 meters high, razor-wired, electronically surveyed wall at the Belarusian border, erected in 2022, increased the risk of serious and potentially deadly injuries for those seeking protection in the European Union. In addition, NGOs reported cases of people, including children and pregnant women, who were trapped in the area between the two borders, which we called dead zone. Those people were exposed to hunger, to thirst, to violence. Moreover, humanitarian assistance provided by activists in the near border area continued to be penalized. For instance, when the group of activists threw food and clothes to the migrants on the other side of the wall, they were punished by the border guard. Fortunately, the court held they didn't act anything contrary to the local law. At the end of 2023, parliamentary elections were won by the opposition, so civil society organizations had hoped that this would be followed by a change in the national border policy. However, no significant changes were observed so far. Moreover, on 15 June 2024, so 1 week ago, the Minister of the Interior and Administration signed a regulation introducing a temporary ban on staying in a specified area in the border zone next to the Belarusian border. The regulation introduced a temporary ban for a period of 90 days from the date of the regulation's entry into force on staying in a specified area in the border zone. The zone includes a ban on staying along a 60-kilometer section of the border. In a section of about 44 kilometers, the area covered by the ban extends 200 meters from the state borderline. In a section of about 16 kilometers, located in the area of nature reserves, the zone is about 2 kilometers. According to the minister and the border guard, the introduced measures aim to ensure the safety of local persons, yes, and the officers, for example, border guard, as well as to limit the activities of smuggling groups facilitating illegal migration. It should be emphasized that the regulations under which the zone was introduced are not constitutional and were criticized by the Polish ombudsman as early as 2021, because this restriction is introduced by a lower ranking act than the Constitution requires for limitation of citizens' rights and freedoms. However, the authorities indicate that this is necessary for the protection of the state border. NGOs providing assistance at the border are concerned as their access to the border has been severely restricted. Sorry. The detention of asylum seekers is also a common problem. At the moment, there are 6 detention centers in Poland. In these facilities, people have limited access to the internet, computers, or phones. Moreover, the living conditions are sometimes critical. Detention centers are also overcrowded. The law allows lawyers, NGOs, and UNHCR to, I'm very sorry, to access detention centers. Detained asylum seekers are entitled to maintain contacts with lawyers or NGOs directly and by using email and telephone calls. But direct contact can be limited or restricted completely by the head of the detention center if it is necessary to ensure safety and public order or to observe the rules of stay in the detention center. The decision of the head of the center is final, so we cannot appeal it. Since 2022, NGOs visit detention centers regularly, funded from other sources of financing. On the other hand, there is no state-funded systematic legal assistance to foreigners granted by law. Asylum seekers are entitled to material reception conditions during all asylum procedure as well in Poland. However, these amounts aren't enough to satisfy the basic human needs. The government assures that the migration strategy currently being developed for 2025-2030, which I will also say a few words about today, should improve the situation. On the other hand, at this moment, as NGOs, we absolutely don't see this. Okay, so the slide has been changed already. Mr. Professor, do you...
3. Yeah. So I can see
temporary protection, yes.
3. Yeah, Polish-Belarusian border, current problem.
I have no idea what is wrong with that.
Protection for people from
now
Ukraine.
It's okay.
Yeah.
I see that. Oh.
So when you would like to change the slide, so maybe just okay, it will be okay. What I can see. Okay, so.
Okay, so now it's temporary protection, I hope.
Yeah.
Okay, so the situation is quite different for people from Ukraine who are under temporary protection. In response to the war in Ukraine and the activation of the temporary protection directive, I will call it TPD as abbreviation. So after the activation of TPD by the European Council, Polish authorities decided to adopt in March 2022 a special law, the Act on the Assistance to Ukrainian Nationals in relation to the armed conflict in this state. I will call it the special law. This law has been applied retroactively since 24 February 2022. Together with the Act on Protection, the special law implements TPD in Poland. However, it applies only to some persons displaced from Ukraine. Since the very beginning of the war, millions of displaced persons crossed the Polish-Ukrainian border. In total, in 2022, it was almost 9.5 million people. In 2023, it was almost 9 million people. Only some of them were registered as temporary protection beneficiaries in Poland. However, until the end of December 2023, in total, over 1.7 million persons were granted special temporary protection in Poland, and they are still with us. In May 2024, Poland prolonged the validity of the special temporary protection until 30 September 2025. Special temporary protection arising from the special law is available only to Ukrainian nationals who reached Poland on or after 24 February 2022 due to the war in Ukraine. And also some of the non-Ukrainian family members, for example, their spouses and the closest family of the Ukrainian national who has a Polish card. Polish card is a document confirming that the person concerned belongs to the Polish nation. Poland didn't extend the personal scope of temporary protection to displaced persons from Ukraine other than the ones I've already mentioned, but some special rules have been introduced in the case of, for example, people who came to Poland before 24 February 2022. For example, validity of national visas issued to Ukrainian nationals was prolonged by law to 30 September 2025 if they were to expire after 24 February 2022. The same with temporary residence permits, Polish identity documents, and tolerated state documents as well. So I'm changing the slide.
Yeah.
Maybe.
Yeah, we can see. Yeah.
Maybe
Slide
I will
number-
just leave it like this. Is it visible? Is it okay if I leave it like this? Because I see that there are some problems if I just switch it to the full screen. So maybe now is better.
Yeah.
Ukrainian nationals and some members of their family who are eligible for temporary protection under the special law can register with any of the local authorities to obtain a special personal identification number. We call it PESEL UKR. Obtaining this number is not mandatory. However, access to some rights is conditioned upon acquiring it. In July 2022, the electronic document DAPL was introduced and notified to the European Commission as a residence permit required under the TPD. However, in 2022, children, in particular those under 13 years old, struggled with accessing the DAPL. Persons excluded digitally struggled with this solution too. DAPL is accessible only via the mobile application. We call it mObywatel. And of course, only after the temporary protection beneficiary obtains the PESEL UKR for Ukrainian nationals. So this is the main problem for people who are just excluded digitally, as that they use it without mobile and without this application. The facilitated possibility to apply for a one-year temporary residence permit was introduced in January 2023. It can be issued until 30 September 2025. Moreover, since April 2023, special temporary protection beneficiaries can also apply in a facilitated manner for a temporary residence permit related to the work or business run in Poland. Since 1st of July 2024, special law is going to provide for the right of a special temporary protection beneficiary to receive a residence card if they had a PESEL UKR on 4 March 2024. they continue to have this number on a day of applying for a residence card, and they stayed in Poland for at least 365 days. It is to be valid for 3 years and is to be understood as having a temporary residence permit in Poland on a regular basis. It will enable working without a work permit and notification obligation and running a business in Poland. However, a person must inform the authorities about every change of their place of stay. Sorry for that. Temporary protection beneficiaries have freedom of movement within Poland, within territory of Poland, and with the DAPL, with this application, also to other European Union member states. If it comes to accommodation, most of the persons displaced from Ukraine are living privately in Poland, over 90% of persons. At the moment. However, there are still a lot of people using collective shelters. In April 2024, it was around 40,000 beneficiaries stayed in the centers contracted by the regional or municipal authorities. Since 1st of March 2023, the cost-free accommodation is limited to 120 days. It is considered to be against Article 13 of the TPD. After this period, especially now since May 2023, if a person concerned lives in the accommodation organized by regional or other Polish authorities, they must cover 75% of the costs, but no more than 60 zlotys per day per person. It is around 12 euro. These rules don't apply to the most vulnerable temporary protection beneficiaries. They can live in the centers cost-free. As it comes to employment, since 24 February 2022, in addition to the previous rules concerning third country nationals, previous rules concerning third country nationals, labor in Poland, Ukrainian nationals are entitled to work in Poland if they enjoy special temporary protection in Poland, of course, and or they are staying legally in Poland on a different basis. And there is a third thing which must be met. So this is this notification procedure. We call it like this. So the employer has the obligation to inform online within 14 days from the start of the work a labor office about hiring a Ukrainian national. Work must be provided in accordance with this notice. It must be performed in no less time than indicated in the notice and paid no less than the remuneration indicated therein. Ukrainian nationals who enjoy special temporary protection in Poland or stay legally in Poland can also register as unemployed persons in Poland. As it comes to education, while education is mandatory in Poland to the age of 18, many Ukrainian pupils staying in Poland are not attending Polish schools. This is more than 50% of pupils. Instead, they can participate in online lessons organized by Ukrainian authorities. If that is the case, a parent or another guardian must inform Polish local authorities that the child is continuing education online within the Ukrainian education system. However, not all parents fulfill these informative obligations. Moreover, some children who are supposed to be attending Ukrainian school online are not going to any school in practice. According to the Ministry of Education and Science, there is no legal possibility to monitor whether children staying in Poland are really attending Ukrainian online schools. Other children try to attend as well both Polish in person and Ukrainian online schools. So this is kind of people, and this we estimate as 30% of the total number of all Ukrainian pupils in Poland at the moment. And as it comes to benefits, so access to benefits, special temporary protection beneficiaries having a personal number and staying in Poland with children are entitled to family benefits. The general rules regarding those benefits apply to special temporary protection beneficiaries almost the same as for Polish citizens. Ukrainian nationals and some of their family members enjoying temporary protection can also access the general healthcare system in Poland. Obtaining PESEL UKR beforehand hand, is not necessary. However, it may be useful. A person having PESEL-UKR is presumed to be entitled to medical assistance. In practice, temporary protection beneficiaries not having this number face difficulties in accessing medical assistance. Temporary protection beneficiaries has also access to some social welfare support services. So, as you can see, this is a huge difference between the level of security for those using temporary protection and those trying to cross the Polish-Belarusian border. Okay, I see that we are running of time, so I would like to conclude by mentioning some more about the migration strategy that is currently being developed in Poland. This is an interesting piece of news. The Ministry of the Interior and Administration has started work on creating a migration strategy for Poland for the years 2025-2030. Until now, Poland has not had such a strategy. Nor has it had a stable and consistent approach. Last week, surveys were sent out of entities involved in broadly understood migration policy. So, for example, NGOs, public offices, consulates, employment agencies, schools, etc., etc. So several thousand entities. The final deadline for returning the completed survey to the Ministry of the Interior and Administration is the end of June. The survey includes questions regarding the areas which you can see on the slide. These areas are also to be regulated by the migration strategy. A report from the survey is to be prepared in July-August. The first draft of the strategy is expected to appear in September. Then there will be a public consultations I think between October and November. And the final version of the strategy is to be developed in December. So the result of the work on the migration strategy will also include new legal acts, including, for example, new law on foreigners in Poland. The strategy is to be enforced from January 2025. At least this is a preliminary plan of the ministry. So that's all from me. I hope I haven't burdened you with too much information, but from my perspective, everything seems important as it relates to the current migration situation in Poland, which is not, which is quite important, yes, issue, a public issue at the moment in my country. Thank you for your attention.
Thank you very much.
I am, of course, open to your questions.
Yeah.
Thank you.
Thank you very much, Oscar. So very quickly, now is time for second edition of question and answer session. So do you have any questions? If we have enough time, please remember that there are also some questions in the chat box. But if we will have enough time, I don't know. Okay.
Well, for the first speaker, Cláudio Carneiro, it was an interesting exploration of the dimension of the humanitarian problem that occurs with the Venezuelan people in Brazil. And it's interesting to see the dimensions in order to find a solution. And the exposition was quite descriptive. And my question will be, what is the solution to this situation in which there are many Venezuelan people in Brazil? We are talking all the time about refugees, about migrants. What is the solution that the Brazilian state gives to these people, and what is the solution that should be done to these people? This could be two interesting issues at the stake. And for the second speaker, Magdalena Bartosiewicz, sorry for my pronunciation. Bartosiewicz, sorry. It was a very interesting, very energetic exposition, very interesting about the situation of the Ukrainian people and the Polish strategy for migration and refugee. I was surprised when you said the asylum seekers were penalized in Poland. I understood that there was a penalization in some moment.
May I jump for a moment? No, not asylum seekers, but the activists, humanitarian aid activists were penalized. But no, asylum seekers, no.
And I was very positively surprised about the temporary residence system, what you explained with great energy and so well exposed. But my question for you is, this temporary residence and this residence permit, these Ukrainian people become migrants or become refugees. This means they are asylum seekers. There is a recognition of the special humanitarian situation, or is a special recognition of a special right for a special situation, this temporary protection, but the status is a status of migrants.
So I can start if this is okay.
But I'm sorry, but we have some questions also in chat box from Furhat Ahmad from Pakistan. So to Ms. Bartosiewicz also question: the European Commission proposed to further extend the temporary protection for people fleeing Russian aggressions against Ukraine from March 2025 to March 2026. This will provide certain certainty and support for nearly 4.2 million persons enjoying protection across the EU. Do you think that European Union can afford to sustain all this? And some words on Ukrainian displacement's impact on EU elections. It was one question, and second is, I guess, to all speakers, could any of our distinguished speakers want to respond on the importance of electoral right of climate refugees and environmentally displaced on today's discourse? Okay, so let's start from the Oscar's questions, maybe, and then if you would like to answer on this question, okay.
Okay, so the first question. So the status of persons from Ukraine using this temporary protection. In my opinion, their status is a refugee status. Yes, still, because of course this temporary residence which they have, this is similar to this typical standard way of legalization of stay in Poland. When, for example, you cross the border and you try to live in Poland even without the war and any difficult situations in your country. However, we need to be aware of the fact that Ukrainian citizens, nationals, they won't obtain this kind of residence in such easy way, yes, if the status won't be special, yes. So if I can compare it, I still think that that the status is a refugee status. However, this is just my opinion, yes, because it's not regulated in any way in any legal act. If it comes to Polish legislation, the refugee status is only granted when you apply for asylum according to Act on International Protection. And this is a special act, which is at the moment, of course, Ukrainian nationals can apply for international protection as well, because they can reject, yes, this possibility for having the temporary protection according to this special Polish act and, of course, TPD. And then they can have this refugee status in an official way. However, if I can just, just have my private opinion, according to my private opinion, this temporary protection status is similar to refugee. Yes, so I can consider it like this. If it comes to the question from the chat, it's a very difficult question, yes, because I cannot answer it from, for example, the financial perspective, yes, because the first thing about you which you have in mind if you want, when you want to answer it, is if we can afford, yes, to help our Ukrainian friends on a longer basis, yes. However, we have to also bear in mind that Ukrainian nationals, at least in Poland, they almost all of them, they work. Yes, when I see Ukrainian people in Poland, I am really very proud of them. Yes, that they came to completely a different country without any plan. Yes, what to do here. However, they started to run their business. They started to work. They started to pay taxes in our countries. And bearing this in mind, I think that yes, we can afford to help them even until 2026, 2027, etc., etc. Yes. However, of course, I hope that the war in Ukraine will finish earlier, yes, and they will be able to come back to their countries, to their country, and to their previous life, of course, if they want, because I am also totally aware of the fact that some of them, they decide to stay in Poland or in other countries which they chose to go, yes, after the war broke out. So thank you.
Okay, thank you very much. And question to Cláudio Carneiro. Hello, can you hear us?
Okay. Now I did. Okay. Thank you for the question, Dr. Oscar. It's a very good question. My idea to present the Brazilian scenario and then talk about the solutions. In fact, what we have, I see that Brazil has been doing less compared to what could be done. The government says that this operation that called in Portuguese, Operação Acolhida, in English, Good Reception Operation, initiative, that what the government says, that the initiative supports the voluntary, safe and organized movement of refugee and migrant population, and also seeks new opportunities for socio-economic and cultural integration. But it's not true. It's not true. The objective of the federal government in this operation is to provide a humanitarian response to demands that arrive in Brazil through the border with Venezuela, but in fact, they don't do it. So we have space and budget enough to receive and integrate them. So according to your question, I agree with you. So what more do we need? I have the answer. The solution is political will to integrate them into the Brazilian economic and social system, giving them the same rights about the Brazilian citizen, not to give them a space to live or to survive. That's the truth. So I thank you for your good question, a very good question. So in my opinion, I can say, like a Brazilian people, Brazil has been doing less that what could be done.
Thank you very much for your answer. And we have one more question, if we have enough time, so maybe very quickly, if it's possible. I don't know who is able to answer on this, because this question was to Professor Felipe González, but about the legal status of migrants. So how to differentiate between the migrants and refugees? However, it's been observed that migrants consequently have to be coined as asylees, or does it vary country to country? So, so differences between migrants and refugees. Who is ready to answer on this question?
I can answer, I think, very shortly. According to legal perspective, the difference is very clear. Yes, so the refugee is a person who is forced to leave her home country because of war, because of some kind of persecution, for example, because of religious reasons. Because of other, let's say, so discriminatory actions, which is already happening in this person's country. And migrant is considered as a person who decided to leave the country because of other, for example, economic reasons. Yes, so so this is this legal definition, yes, of how we understand refugee and the migrant. Yes, so thank you.
Okay, thank you. Any other questions? I'm afraid that our time is almost finished. So time for conclusion. I don't know, it could be a conclusion, but someone told such a beautiful sentence. Refugees are mothers, fathers, sisters, brothers, children, and the same with the same hopes and ambitions as us, except that a twist of fate has bound their lives to a global refugee crisis on an unprecedented scale. So, I think that we must also remember that a refugee is someone who survived and who can create the future. So maybe this is a conclusion of webinar. Thank you very much, all of distinguished speakers, for all presentation and very interesting, fruitful speeches. It was truly a great honor for me, and I think for all RC members, RC26 members of IPSA. And I hope that we will meet maybe on the next webinars of RC26 on human rights. So once again, thank you very much for your attending in this meeting, for your opinion, remarks, etc. So I don't know. And thank you very much also to Oscar Pérez de la Fuente. Because we hosted on the Madrid University's platform. Thank you very much, and for your questions, for your impact to this meeting. Thank you very much, Oscar.
Okay, thank you. I think it has been a great webinar, very interesting, and well, since the next time. Thank you very much.
Thank you very much once again.
Thank you. Goodbye.
See you.
Thank you. Have a good evening. Bye.
Thanks, everyone.
Bye-bye. Thank you.